Hello viewers, my name is Lieutenant Junior Grade Thorsten Swider, a Judge Advocate assigned to the Region Legal Service Office, Mid-Atlantic. This video covers the basics of estate planning services offered by our legal assistance offices to better prepare you for your visit to our office and to get the most out of your visit. This video is not designed or intended to provide legal advice, does not form an attorney-client relationship between us, and will not provide details or information about specific estate planning situations. You should consult with an attorney for that information. As with all legal practice areas, we are able to serve active duty military, activated reservists, dependents, and retirees. If you have specific questions about whether you are eligible for legal assistance through the Navy Judge Advocate General's Corps, please contact the nearest legal assistance office and we will be happy to discuss the matter. Estate law, at its core, is law relating to your money and property and how you manage it or give it to others while alive or after you die. The RLSO can assist with several estate planning services, such as wills, trusts, and powers of attorney. We can draft simple wills that are protected under federal law that will be valid in any state. We also offer in-house will signings and executions so that the will we draft for you becomes legally binding. Additionally, we can also review the wills of others where you are named in the will and have any questions about what that may mean. As part of our will services, we can set up a trust for the benefit of your minor children in the event that you die before they become adults. We can also help interpret and demystify trust language and obligations for other trusts that you may be named as trustee or beneficiary. We also have several types of powers of attorney that we can prepare or notarize for you. The Legal Assistance website of the Judge Advocate General's Corps has special powers of attorney you can download and complete and bring to our office for a consult or to have them notarized for use. Please note, though, that while we can notarize all military-related powers of attorney and many civilian forms, certain states have special forms and special requirements for powers of attorney or other documents related to the sale or purchase of real estate. If you have any questions or are attempting to purchase, sell, or refinance your house and have documents that need to be notarized, please feel free to come in and discuss the matter with your legal assistance attorney, and we will see what we can do for you. The services listed here are by no means exhaustive. Legal assistance is here to serve you for any legal needs. If you have a law-related question and do not know where to start, feel free to come into our office and speak with an attorney, and we will help you however we can or point you in the right direction. In addition to in-person services with a legal assistance attorney, the JAG Corps Legal Assistance Office also provides a number of self-serve options to help you with legal needs. Each legal assistance office at a Region Legal Service Office has a self-service kiosk in the lobby, which enables you to fill out and print legal documents such as powers of attorney or in loco parentis forms for your child care. After filling and printing out these documents, you can go to the front desk of the Legal Assistance Office and get these forms notarized, making them legally ready for use. Many of these same forms are available online at the Navy JAG Corps website, where you can view, fill, and print them from home to take to a notary of your choice for signature. On that note, it is important that we make clear that we cannot assist in all legal matters. JAG Corps legal assistance attorneys are generalists who are licensed in different states and are military officers who PCS regularly between duty stations, as does any service member. Therefore, we cannot go to court and be part of any active litigation, and we cannot assist in certain complex estate planning matters. If such situations apply to you, we are happy to provide you with what information we can and will do so free of charge before suggesting you consult with a civilian attorney who can best assist you. A common issue our offices deal with is providing information about estate planning processes or what certain documents mean. If you find out that a family member wants to name you as their executor or trustee, or already has, we are happy to help discuss what those terms mean and what your duties may be. Similarly, if you receive notice that you are the beneficiary of a trust or of property in someone's will, you may be wondering what, if any, steps you need to take or responsibilities that you may have. Finally, you may wonder what a will or trust even is, or what it may do, and whether you need one. These are all questions our office is happy to help with at no cost, saving you the time, energy, and expense of consulting with a civilian attorney for the same information. If you are looking for information related to a will, a trust, or the probate process, and have any specific paperwork related to your situation, please bring it with you to our office. Most states require trustees to keep records and accountings of assets of the trust. If you receive such information or are responsible for such information, please have it ready and with you so that we can best assist you and understand your situation during your appointment with a legal assistance attorney. The bread and butter of our estate planning services is will preparation. It is no secret that being in the military service exposes you and your family to risks that many civilians do not encounter, and it is helpful to be prepared. Therefore, under federal law, legal assistance attorneys are empowered with the ability to prepare simple wills for any of the states, valid nationwide. This ensures that your will can follow you between duty stations without worrying about the differences in state probate laws. To provide this service, the Navy has a standardized will worksheet that all legal assistance offices use. It is available on the Navy JAG website as well as on every RLSO website or for pickup at any RLSO office. Filling out this worksheet does not create your will. Rather, it provides the legal assistance attorney with all the information they need to create your will. Therefore, complete it before coming in to the legal assistance office to consult with an attorney, so the attorney can use the time to review it and ensure that it reflects your wishes. Filling out this worksheet takes time. It is important that you give careful consideration to what you want to have happen to your property and who you want to be responsible for it after you die. Oftentimes, spouses wish to do their wills together to ensure that their wills mirror each other and are consistent. We are happy to do a dual will intake with you and your spouse, but there are several considerations. First, as standard practice, we require that there be one will worksheet per client. Even if you and your spouse want functionally the same will, our offices require that each spouse fill out a will worksheet for themselves and bring it in for the intake. Second, because wills are individual documents, both you and your spouse will get your own will that will require a second appointment to execute. That means that both you and your spouse will have to come in a second time to sign and execute the will, though you need not do this together if scheduling is difficult. Finally, a dual will intake between spouses requires that you both waive your right to confidentiality with the attorney with respect to each other. Normally, an attorney is obligated to keep your discussions confidential to ensure that you can be honest and upfront about your wishes. In a dual will intake, this is impossible. Consider whether you are comfortable discussing your wishes while your spouse is there, particularly if you have a child from a previous relationship. Arguments between spouses have happened during dual will intakes. If they are not resolved immediately, this can prevent your will from being written properly or may cause the attorney to terminate the in-office meeting. As previously indicated, the standardized will worksheet provides the attorney with information to create your will. Included in this worksheet is information that can help establish a trust, name a guardian for your children in the event of both parents' deaths, and will also create non-will documents such as a healthcare power of attorney, living will, and general financial power of attorney. If you have any questions about what any of the fields are asking or what is being created, please ask your attorney during your intake. There are some limitations to what our legal assistance office can do when creating your will. If you are seeking to create a specialized trust, such as a living trust or a conditional trust, example, one that depends on your child graduating college, or complex trusts designed to avoid estate taxes, or special needs trusts in some cases that are designed to preserve eligibility for Medicare or Medicaid. Our office will be glad to discuss the implications of such things, but will not always be able to draft such trusts. As such, We are happy to be a free source of information to the best of our ability, even if we cannot create the will or trust that you seek. Similarly, our office cannot serve clients who wish to create wills that involve property with special tax status or legal status, including the disposition of farms, ranches, oil and gas rights, mine ownership, ownership of large and complex businesses, or estates of significant value where certain tax implications are present. Again, due to the intricacies of state and federal laws involving these types of property, such bequests are best handled by a specialist attorney within your state to ensure that your will is optimized to serve your needs. If you have any questions about such property or are unsure if this applies to your estate, feel free to make an appointment and ask a legal assistance attorney. The next section of this video will go over the will worksheet page by page to assist you with filling out the form so your in-office meeting with a legal assistance attorney goes smoothly. During your meeting with your attorney, you will notice that the attorney is making numerous notes and markings on your worksheet. This is to notate that they have gone over the entire worksheet box by box and to make any notes or comments on the sheet so that the will can be drafted correctly. If you have any questions about what is being marked, please ask. Page 1 is straightforward. At the top, you will see a box labeled for office use only. Throughout the worksheet, you will see a few boxes labeled for office or for attorney use only. Please do not make any marks in these blanks when filling out the form at home or in our office, even if you think you know the answer. Our attorneys are required by JAG Corp procedures to discuss and mark these boxes during the meeting, so you save no time by filling out this information before. In the middle of the page, you will see a series of yes or no questions. Please answer all of them. We need to know up front if any special legal provisions or statuses apply. For example, one question asks if you own a farm. As previously stated in this video, farms have special tax implications that your legal assistance attorney will want to know about if they apply to you. Finally, at the bottom, there is a box for your personal information and contact information. This information is both important for the actual text of your will, so we can get in touch with you, and if you have any further questions later on. Please fill out all the information as it applies to you, and please double check it. We have had clients write down the wrong birthday for their spouses, and while this is an easy fix, it will not save you from your spouse's annoyance if they catch you first. Finally, please print clearly so that the attorney will not have any problems reading your answers. The top of page 2 asks for a series of questions about your contacts with different states. This is important so we draft your will in accordance with the state that's most legally significant to you. While federal law ensures that your will remains valid in all 50 states, it also requires that we name you as a resident of a particular state. Additionally, the state where you have the most contacts will likely be the state that probates or otherwise deals with your will on your death. Therefore, your legal assistance attorney needs this information to pick the most appropriate state to ensure that your will, if needed, is most effectively and efficiently carried out. Below the state information is information about your family. Specifically, the worksheet asks about any children, including adopted children and stepchildren, as well as prior spouses that you may or may not have. There are also a series of questions concerning how you want children to be addressed in your will. While state laws vary slightly, virtually all states do not treat stepchildren identically to biological or adopted children under estate law. If you want stepchildren to inherit anything from your estate, please notate their information on this page and be sure to discuss with your attorney what your wishes are so that it can be included in your will. In addition to children, please fill out any prior spouses. Depending upon how your marriage ended and what any courts included in the divorce decree, there may be constraints on what you can give away in your will. If this applies to you, please be sure to mark it on the worksheet and discuss with the attorney. Finally, at the bottom, there is a blank for your net worth. When filling this out, please turn to the last page of the will worksheet where there is a table you use to list your assets and approximate net worth. This is important to ensure that estate taxes are not a concern, as well as to give the legal assistance attorney an idea of what types of property you own that are being disposed under your will. Therefore, it must be completed thoroughly and accurately. Writing a stock portfolio that is worth unknown dollars is not helpful. Page 3 of the will worksheet deals with what is called PreResiduary Assets. Specifically, this page addresses important pieces of property that should be specifically addressed and dealt with separately from everything else you own. The first section deals with real estate. If you own a house, land, or similar property, fill out the boxes corresponding to your wishes. If you do not own any real estate, you can skip this section entirely. However, this section should not simply address real estate you solely own. If you share a family home with your spouse, but your spouse's name is the only one on the title and/or mortgage, you should consider what you would want to have happen with the home if you inherited it from your spouse should they die first. If you have questions about your particular situation, ask your attorney. Below the first block about how you want real estate to tax is a section concerning mortgages. Please read the options carefully and select appropriately. Importantly, consider how much the mortgage or other liens against the property may be and whether you have enough money in your estate to pay off these debts. The final section at the bottom deals with specific bequests of personal property. This section covers specific, non-real estate items of property that you want to give to a named person in your will. For example, graduates of service academies commonly have memorabilia that they want to pass to friends and fellow graduates. This section would be the place to list those desires. Your attorney will discuss with you the best means of ensuring that your property gets to who you want, so be sure to discuss any such bequests or concerns you may have during your intake. Additionally, while not specified anywhere on this version of the worksheet, your legal assistance attorney will ask you how you want the rest of your tangible personal property to be dealt with. This includes all non-monetary items that you did not give away specifically in the bottom section, such as books, clothes, furniture, etc. Your will contains a section specifically giving this property to whoever you name, so your attorney will ask and notate it on the sheet. By filling out the worksheet, think about who you want to give this property to, since it is often a large amount of stuff that needs to be sorted and dealt with. The top of page 4 contains a section for cash bequests. This is just as it sounds. If you want to pull money out of your estate, such as your bank accounts, on your death and give it to a person or charity, specify so here. The remainder of page 4 is what is called your residuary estate. This covers everything else you own that has not been spoken for in the previous sections of the worksheet. Your residuary estate is likely to be large and valuable as it will contain bank accounts and other assets, so think carefully about how you want it to be divided, if at all. If listing specific people or alternate beneficiaries, please note that if anyone named is a minor child, your attorney will need to know, as this potentially requires a trust, custodianship, or guardianship to be set up in your will. Finally, while not specified anywhere on this version of the worksheet, consider if you have any online accounts such as a Facebook page or a blog. You have a legally protected interest in the information and passwords related to these pages, so if you want your executor to be able to access these after your death, be prepared to let your legal assistance attorney know so it is included in your will. The top of page 5 discusses disinheritance. If you want your attorney to include specific language that cuts someone out of your will, name that person here. You can list anyone in these spaces, and your attorney will discuss it further with you during your intake to ensure that your will reflects your wishes. Following disinheritance is a section where you name your executor and any alternates. Being the executor of an estate is no small task. It takes time and effort even for small estates. It should be someone you trust to carry out your wishes, as well as someone who is able to shoulder this responsibility. Therefore, it is a good idea to ask the person you're thinking of before putting it in your will. You are not required to list alternates, but it's always a good idea in the event your first choice is not available. Otherwise, a judge may have to appoint an executor. and you will not be alive to object if it is someone you do not know or trust. Section 3, towards the bottom of page 5, begins the section on trusts. If you do not have any minor children and are not leaving any part of your estate to any minor children, you can skip the rest of this and all of page 6. If you have minor children or intend to give minor children any part of your estate, you will need to discuss with your legal assistance attorney about the best way to meet your wishes. An 8-year-old cannot legally own your house, so you will need to decide when and how you pass such property to that child. There are several choices for ages that you can check on the page, or you can also select your own age if none of the ones are appealing to you. Think carefully when choosing an age, since that is the age at which your child will take whatever you give under the will. As always, ask any questions to your legal assistance attorney, and they will go over this section meticulously with you to discuss any implications. Page 6 begins with information about your trustee or custodian. A trustee or custodian is responsible to manage the assets given to a child until they attain the age specified in your will. Being a trustee or custodian is a large responsibility with legal requirements that last until your children attain the age you specify in your will. Therefore, you should think carefully about who you choose, make sure that they are ready and willing to serve in these important roles. Consider naming an alternate in case the primary person cannot serve. The bottom half of page 6 involves naming guardians for your children. Your guardian will be the person who cares for and raises the children if you and the other child's parent are deceased or incapacitated. You can name the same person who is your trustee to be your guardian, but this adds even more responsibility, so be sure that you select someone you trust and who is willing and able to both house the child, act as their parent, and also manage all of their trust assets. As always, please consult with your legal assistance attorney for any questions or specifics, and your attorney will speak with you at length about this during your intake process. The top of page 7 begins with a section on monthly benefits for your children. Here, you can specify whether you want your guardian or your trustee to handle monthly payments, such as Social Security income, that your children may be entitled to, independent of what you've passed in your will. This section is important, so if you believe it may apply to you, please discuss with your legal assistance attorney during your consult. The following section addresses SGLI policy and death benefits. Both of these are significant sums of money that pay out to you on your death, but your will does not control where this money pays out. However, since both are related to military service, your legal assistance attorney can advise on how to change your SGLI and death benefit to mirror your will. If you do not have SGLI, are a dependent who is not eligible, or you have already set things up how you wish, then please notate appropriately and let the attorney know during your intake. The next section addresses special needs beneficiaries. If you have a beneficiary that has special needs and receives government benefits due to these needs, you may need a special needs trust. As indicated in the beginning of this video, not every legal assistance office in any region legal service office can set up a special needs trust due to the highly specialized nature of these trusts and the significant tax and benefit implications involved. However, we are happy to consult with you and refer you to an agency that specializes in creating or managing these trusts if we are not able to help. The bottom section of page 7 addresses how you would like your remains to be handled on your death. The 3 most common choices are listed: burial, cremation, or donation, but this is not an exhaustive list. If you have a special desire for your remains, you can let your legal assistance attorney know and they will notate it and include it in your will. However, special requests are not legally binding and subject to federal limits and state limits. For instance, if you want the President of the United States to attend your funeral, your attorney can mention that in your will, but we cannot guarantee that that will happen. Clients are sometimes confused by how these choices interplay or interrelate. If you are a service member, veteran, or retiree, you are entitled to a full military honor ceremony, even if you are cremated or donate your body. The DoD has protocols for each ceremony based on how you select. Similarly, eligible service members receive an American flag from the Department of Veterans Affairs for free and can also purchase additional flags. Please let your legal assistance attorney know any questions that you have or what your specific desires are, and your attorney can notate it and write your will so that it best reflects your desires. Pages 8 and 9 address powers of attorney that we provide as part of our estate planning process. However, these are not part of your will. These sections are optional. You can still get a will done without completing these. If you so choose, leave them blank and let your attorney know during your consult. However, we recommend completing these sections as they are useful tools to ensure that your needs are taken care of in the event you are still alive but incapacitated. The first section, page 8, addresses the power of attorney for healthcare. The information at the top briefly explains what this power of attorney does. In short, it takes effect in the event you become incapacitated and someone needs to make medical decisions on your behalf regarding your care. Complete the boxes with the full name and contact information for whoever you designate to make these decisions. Because this power of attorney only comes into effect when you are incapable of making your own wishes known, and at a time that this is likely to be stressful for your family, it is a good idea to talk to whoever you name as your agent so they understand what their duties will be, and it is also a good idea to have an alternate planned. As always, ask your attorney if you have any questions or doubts. Below the medical power of attorney designation are questions related to organ donation in the event of your death. If you have already opted into your state's donor registry, this section may not be needed, but discuss the matter with your attorney to ensure that your wishes are properly reflected, especially if you have possibly changed your mind. Below organ donation is a section related to home hospice or death. Many clients know that they would feel more comfortable and at ease if they were terminally ill and spent their last days at home or in a hospice setting instead of a traditional hospital room. This section allows you to express your wishes, but please note that they are not necessarily binding based upon your particular medical situation. As always, please discuss the implications of this and any questions with your legal assistance attorney. The next section deals with the creation of a living will. Many states call this document different things, and many states treat these documents differently, so it is important to discuss your options with your attorney. This document is different and separate from your healthcare power of attorney and serves to make your wishes known if you are on life support or some other form of artificial medical support indefinitely. You will be unable to express your wishes, and if a physician determines that you have no meaningful chance of recovery, having a living will allow you to make your wishes known ahead of time if you want this care to continue. Living wills became a hot topic in state healthcare laws following the Terry Schiavo case in Florida, for those of us old enough to remember when that was in the news. Such decisions have enormous emotional, legal, moral, and spiritual or religious implications for clients, so please discuss with your family and with your attorney to ensure that you understand the choice you make. The top of page 9 begins with a final note on living wills and only applies to biologically female clients who are capable of bearing children. If this applies to you, please note whether or not you would like your living will to have an exception in the event you are pregnant. The next section on page 9 discusses a second power of attorney, a springing, durable general power of attorney. This power of attorney is separate and different from the healthcare power of attorney and different from your will. It empowers your agent to make virtually any legal decision on your behalf related to your finances or your property in the event that you become incapacitated. Because this is an enormous power, it should not be given lightly, and you should discuss the full implications of the power with your legal assistance attorney. You can opt to have the same people you named as your healthcare agents as your agents under this power of attorney, or you can name new agents in the space provided. The final lines at the bottom of page 9 are for you to sign if you are comfortable with us sending a draft of your will to you via email. As the draft will contain sensitive information and personally identifiable information, we need your explicit consent before sending it in electronic format. Please remember that the copy that we send you by email is not legally valid. It has not been signed, notarized, or properly executed, so it is only for the purposes of reviewing and providing comments or corrections. Finally, while not pictured in this video, page 10 is a listing of your assets. We encourage that you thoroughly and completely fill this out for your attorney's information during your consult. If it is not filled out, the worksheet will be returned to you in the waiting room prior to seeing an attorney for completion. Thank you for watching this video. I hope it explains some of the services we offer you at the RLSO Legal Assistance Office and helps you better prepare for your consult with us so we can ensure you get the most out of your time and out of our legal services. If you have any questions, please reach out to your nearest legal office and we will be happy to assist you however we can. The mission of the Navy JAG Corps is to support the warfighter and their families, so we will do whatever we can to either solve your legal issue or point you in the right direction of a solution. Thank you for your service, or thank you for your support.